It is true that an at-will employee can be lawfully terminated for any reason, fair or unfair, or no reason at all, with or without notice. However, it is still illegal to terminate an at-will employee for discriminatory or retaliatory reason, and these types of terminations will form a basis for a claim against that employer. It is true that the employer doesn't have to give their at-will employee the reason for termination under the law. They don't have such an obligation. You can just terminate the employee without giving them any reason at all. However, in many cases, it's not a good idea not to tell the employee the reason that you're firing them, because it will likely raise a suspicion in that employee's mind that the real reason for their termination is fishy and illegal. Example, let's say you have an employee who you're about to terminate, and he or she happened to be of a particular religious or racial minority in general and at their workplace, or that employee just returned from disability leave, or they're about to take FMLA leave, or they requested a disability accommodation, or maybe they recently complained about sexual harassment at work, or maybe they filed a workers' comp claim. When you terminate them and you tell them, I'm not telling you why I'm firing you, of course they will start suspecting that the reason you're not telling them why you fired them is because you know that what you're doing is illegal. So they will start speaking with lawyers, telling them the story, and many of those lawyers will rightfully suspect that if the termination followed shortly after one of those events, harassment complaint, accommodation request, family medical leave request, those lawyers will rightfully suspect that the reason for termination is retaliatory due to one of those events. So sometimes it's a good idea to give the reason for termination. In fact, probably in most cases, it's a good idea, especially if your reason is reasonable and honest as an employer.